Just a minute. It was his further statement that consequent upon the termination, he approached the legal aid counsel to write a letter of demand to the defendant demanding his salary for the month and his salary in lieu of notice. Excuse me, whoever is talking there, the meeting is already in session. It was his further statement that consequent upon the termination, he approached the legal aid counsel, letter of demand to the defendant demanding his salary for the month and his salary in lieu of notice, wherein the defendant by a letter and attach a check of 28,000 naira as a salary in lieu of notice, for which he queried the basis of the issuance of the said check, read the letter to the defendant and averred that the defendant has not communicated or reached out to him nor acceded to his demands. The defendant, on the other hand, responded by filing its statement of defense, written statement on oath of its witness and all other accompanying documents. It is the case of the defendant that he admitted that the claimant was his employee who was placed on a monthly salary of 120,000 naira, but flatly denied that the claimant performed his job diligently. It is also the defense case that the claimant was issued 2 warning letters over misconduct and underperformance prior to the termination of his employment, and that upon serving claimant the termination letter, claimant was issued a check of 28,000 naira representing his salary in lieu of notice, which he rejected. The defendant denied liability of all claims. At the close of trial, the defendant filed its final written address, wherein it is still one issue for determination that has been reduced. An argument in support of same has equally been summarized into the body of the judgment. The claimant equally filed his final written address and adopted the defendant's sole issue that has equally been reduced into the body of this judgment. I will now go straight to the decision of the court. I've given a careful and insightful consideration to the originating process in this case, the statement of defense and the issues framed by parties. I am of the view that the issue that will best determine the justice of this case is whether or not the claimant is entitled to the relief sought in this case. The grounds of the claimant for instituting this suit on 26th of November 2020 is that the termination of his appointment on the ground of underperformance without the issuance of 2 warning letters is unlawful. It is wrongful and null and void have been issued. The defendant, on the other hand, denied it and asserted that the claimant was on 2 occasions issued queries and warning letters over misconduct and underperformance prior to the termination of his employment, herein tendered copies of the acknowledgement copies of the alleged warning letters. It is barefaced on the record of this court that the employment relationship between the claimant and the defendant is one of master-servant. Undoubtedly, the nature and implication of employment relationship of that status is that such employment does not serve as statutory flavor. It is thus founded on common law principle. The necessary implication arising from such contractual relationship is that, like all general contracts, it is determinable by either side as provided in the documents for breaches of any fundamental condition as stipulated therein. So the case of Ekwala and CBN citation captured, the case of Oak Pension Limited and others versus Olayinka citation is equally captured. Any employment not governed by statute is a master and servant employment relationship. Such employment is governed by the terms under which the parties agree. See the case of Kwara State Judicial Service Commission and Tolani citation captured. This action is no doubt a declaratory action wherein the claimant must rely on the strength of his own case and not on the weakness of the defendant. The necessity for this arises from the fact that the court has a discretion to grant or refuse the declaration, and the sources of the claimant in such an action depends entirely on the strength of his own case and not on the weakness of the defense. See the locus classical case of Cordelier and Banifodu, citation captured. The case of Akiola and others, Zolo and 2 others, citation is equally captured. The case of Vincent L. Bello versus Magnus Iweka citation is also captured. It is a position of the law that an admission of a defendant in a declaratory action cannot stand as a proof of the claimant's claim. However, the claimant is at liberty to make use of a defendant's case that support his case. Parties are in consonant that the claimant was an employee of the defendant. The only areas of dispute are, while the claimant by his beliefs 1 and 2 is alleging that the defendant terminated his appointment on the grounds of underperformance without the issuance of 2 warning letters and without notice and salary in lieu of notice. The defendant denied and stated that the claimant was on 2 occasions issued queries and warning letters over misconduct and underperformance prior to the termination of employment and was contemporaneously issued a check of 28,000 naira representing his salary in lieu of notice, but the claimant rejected it. As reasoned earlier in this judgment, the onus of proving the relief sought by the claimant lies on him. The claimant claiming that his employment was unlawfully terminated must plead and lead evidence to establish same. See the case of Ibilu and CBN citation provided, the case of Lunge and FBN citation equally captured. The claimant has been able to establish a prima facie evidence in proof of her employment relationship with the defendant by Exhibit U, that is his letter of appointment, to which his terms of employment was attached. The term specifies the manner his employment may be terminated. He has equally evinced the amount of his salary monthly paid to him by the defendant. This is as pleaded in paragraph 4 of his statement of fact and also paragraph 7 of the letter of appointment. I now capture paragraph 7 of the letter of appointment, which stipulates the salary of the claimant does. That your appointment is coupled with a monthly salary or allowance of 120,000 naira, unquote. Same was signed by him and the defendant agreed upon to serve as a binding agreement between the parties. See the case of Statoil Nigeria Limited and NNPC citation captured. The Court of Appeal held that parties are bound by the agreement. In that regard, the burden on the claimant to adduce prima facie evidence in proof of his employment, terms of employment, and the manner of which it can be terminated has been satisfied. The defendant, however, did not deny his relationship with the claimant and his monthly salary. It is tried law that facts admitted need no further proof. See the case of Ashafa Foods Factory versus Arain Nigeria Limited citation captured. I thus find that the claimant has established that he was in the defendant's employ and the terms and conditions of employment is as stated in the attached schedule of his appointment letter, that is Exhibit U. Consequent upon which, I find that Exhibit U constitute the terms and conditions of employment, of claimant's employment, and same is to be construed in determining the rights and obligations of the parties. In this case, I so find and hold. The claimant pleaded in paragraph 9 of his statement of facts that he replied to the letter of termination, that is Exhibit U1 dated 21st January 2019, via a letter of demand, Exhibit U2 demanding a salary in lieu of notice. The said letter is dated 9th of March 2019. The defendant, in response to the aforesaid, in paragraph 6 and 7 of their defense, admitted the facts therein and also relied on the correspondences mentioned therein during the trial. First, I am aware the letter of termination is dated January 21st, 2019, a date that predates the date of appointment of the claimant by the defendant, which is the 1st of July 2019. The reply by the claimant to the letter of termination thereto also predates the date of his appointment. The claimant alluded to the facts in his pleadings that the defendant wrongly dated the letter of termination, which then follows that the letter of termination dated 21st of January 2019 is admitted to be a mistake as the termination cannot predate the appointment date. The claimant also averred that his reply to the termination letter is dated 9th March 2020. The defendant, on one hand, neither denied same. On the other hand, neither denied same, as it is tried law that fact admitted need no further proof. More so, parties are bound by their pleadings. I, however, hold that the obvious mistake goes to no issue. Now, what is the manner agreed upon by both parties in the event of termination of their contract? As stated in the terms of contract before this court, that is Exhibit U, I find at paragraph 10 of the terms that I quote, the company shall only terminate your appointment after 2 warning letters has been given to you for lack of performance, bad behavior, insubordination, misconduct, and failure to adhere to the company's policies, unquote. It is deducible from the above captured paragraph of the contract of claimant's employment that it may only be sacked by termination after 2 warning letters have been issued for any of the above offenses. The claimant in his pleadings averred that he was never issued any query or warning letter, but averred when cross-examined by the defendant's counsel in his testimony to have acknowledged the receipt of one of the 2 warning letters, Exhibit E1, and was punished by a deduction of 10,000 naira from his salary by the defendant to that effect. He denied being served Exhibit E. He went ahead in his final written address to say that Exhibit E1 cannot be counted as a warning letter preceding the termination of his employment, and claimed that his signature was forged in Exhibit E. Flowing from above, I must agree with the submission of learned defense counsel that the piece of evidence eluded by the claimant in his final written address will go to no issue, as that piece of evidence was neither contained in claimant's pleadings nor in his written deposition during his examination, as it is the law that address of counsel, no matter how brilliant or beautifully made, cannot make up for want of evidence or adequate evidence to prove and establish points or issues in a case. See the case of Danladi and Rufai, citation captured. More so, forgery is a component of fraud, and for the court to determine whether or not there was forgery of the signature of the claimant as contained in Exhibit E, the claimant must specifically please same the claimant and give particulars of same. The claimant, however, who wants the court to believe that he did not acknowledge the receipt of Exhibit E, has to prove beyond satisfaction to that effect, either by a testimony of a handwriting expert to prove otherwise, which he has failed to do in the circumstance. It is a cardinal principle of our law that document speaks for itself and cannot speak through the testimony of a witness or witnesses or read into a document what is not therein contained. See the case of Capital Hotels PLC versus Abdullahi, citation captured. The claimant, having acknowledged the receipt of Exhibit E1, and on a careful look at the handwriting acknowledgements on both Exhibit E1 and E and E1, I must say the handwriting look the same to me. And it is tried law that when a court faced with any issue bordering on signature on documents before it, the law demands that the court compare the 2 signatures or any other documents or record with the signature of the party in contention to see whether or not they are similar and make its inference from same. See the case of Aye Juni and Company Nigeria Limited and another versus Akin Jagunla and another citation captured. The case of Uyua versus Paul and another citation equally captured. In this instance, suit, the claimant who tendered both documents Exhibit E and E1 has averred to have acknowledged the receipt of Exhibit E1. The signature on Exhibit E1 then becomes the template signature with whom to compare the signature and handwriting on Exhibit E to see if both are similar. I've critically looked at the signatures and handwriting on both documents, and I find that the acknowledgement of receipt on Exhibit E seem to be same with Exhibit E1. It is therefore obvious that the claimant received both Exhibit E and E1, which were tendered by him. I wonder where claimant got Exhibit E from if he did not receive it from the defendant. Just a minute. If he did not receive it from the defendant. Let me take that again. I wonder where claimant got Exhibit E from if he did not receive it from the defendant. I hold that claimant was the one who acknowledged the receipt of Exhibit E. Now, can it be proper for the court to find that the termination of the claimant's employment was in accordance with the terms and conditions of employment, having received both Exhibits E and E1. Put in another way, will it be proper to find that Exhibits E and E1 fulfill the condition for termination of claimant's employment by the defendant? I must say that the terms and conditions of claimant's employment clearly stipulate at paragraph 10 that 2 warning letters should be issued before termination in the event of the following offenses: quote and unquote, lack of performance, bad behavior, insubordination, misconduct, and failure to adhere to the company's policies. The reason given for termination of claimant's appointment, which was quote and unquote underperformance, doesn't mean claimant has to be given 2 warning letters only in respect to underperformance when the terms and conditions of employment clearly state otherwise. The above terms are clear and requires no special aid to understand. It is as clear as crystal that even though the claimant's employment was terminated on the grounds of underperformance, his employment can also be terminated consequent upon any of the offenses stipulated in the terms thereof, so far as 2 warning letters are issued in that regard before termination. The defendant in this suit asserted that he gave the claimant 2 warning letters in accordance with the terms and conditions of employment before terminating claimant's employment. It is important to note that what is before this court are 2 query letters, Exhibit E1 and E, not warning letters. A query by Webster Dictionary of English Language, the Lost Edition, by J.G. Ferguson at page 794, defines a query as, I quote, to inquire into, to ask about, to ask questions of, to interrogate, to express doubt concerning the correctness or truth of, to have or express doubt, unquote. Simply put, a query letter is a written details informing an employee of an unsatisfactory behavior and to call upon him or her to submit within a specified time such written representation as he or she may wish to make to exculpate himself or herself from disciplinary action. While a warning letter is a formal letter, on the other hand, is a formal letter and is used as a mode of corrective measure of communication instead of termination. It is issued by an employer to an employee after he has been found culpable of an offense he was queried for. A warning letter is more like a fair and reasonable opportunity given to an employee to amend his or her ways after the decision of a defendant in its pleadings and the argument canvassed by learned counsel for the defendant in the final written address that the claimant is trying to mislead the court into believing that the 2 letters of query should be seen as 2 warning letters. That seemed to me to be an afterthought to justify its wrong. The defendant ought to have been abreast with the terms and conditions guiding the employment relationship with the claimant. Exhibit E, which is dated November 5, 2019, issued to the claimant, the content of which is captured hereinafter for ease of reference, state thus, and I quote, it is addressed to the claimant, titled Query Letter. The management frowns at your lack of performance and on seriousness to work based on your appointment with the company that you are to close a minimum of 10 deals monthly. So far, you have not closed or brought in any deal and will rely on employees to perform their jobs to the best at a satisfactory level, as well as to abide by our policies. We hereby request you to submit a written explanation for your lack of performance and inability to deliver on the tasks assigned to you within the next 24 hours. A copy of this letter shall be kept in your office personal file. Kindly treat this as an urgent matter, signed management, unquote. Then I have highlighted the content of Exhibit E1, I quote. It is titled Internal Memo Title Query to Ugwagu Sule, Acting General Manager, from GMD/President. Explain within 2 hours why disciplinary action should not be taken against you for holding board meeting in my absence. By this act, you will be surcharged 20,000, but it's 10,000 are written in the bracket Naira to forestall future occurrence. On no account should you hold any boardroom meeting without any express instruction and directions on what to be discussed for the week henceforth, signed by GMD President, unquote. It is plain on the above captured two letters that they are query letters. This is clearly shown on their title. They are unambiguous and so plain. It is equally clear, respecting the content of the queries, that the claimant was questioned for underperformance in the first query, Exhibit E, and in Exhibit E1, it was queried for holding a boardroom meeting without the consent of GMD President of the defendant. The defendant in both letters demands explanation from the claimant that, going by the definition of a query produced supra, cannot by any chance be regarded as a warning. I thus have no hesitation in making a finding that the defendant did not give the claimant two warning letters before terminating his employment as required by his contract of employment. Learned Defense Counsel argued that the claimant did not controvert the defendant's assertion that he was given two warnings before determining his employment. The law is long settled that he was said must prove. The claimant who first asserted with paragraph 5 of his statement of fact that he was not issued any warning letters before the termination of his employment has the onus to prove first that he was not issued the warning letters. Then the onus will shift on the defendant who has said that it's issued two warning letters to the claimant. The law is that the onus of proof preponderates depending on how the scale of evidence preponderates. See the case of NSA and others versus Enene and others, citation captured. Okay. Sorry, Learned Counsel. Although the law, can you hear me, please?
Yes, I can, my lord. Okay. Yes, I can, my lord.
Very well. Although the law is of commonplace that the onus of proving breach of contract of employment rests on the claimant who asserts same, I've held supra that the claimant has been able to prove with cogent and credible evidence that he was not issued two warning letters before the defendant terminated his employment as reasoned above. However, whereas in this present, the defendant has said that it issued two warning letters to the claimant, the onus of substantiating its assertion rests on it and not on the claimant any longer. I find this to be lacking on the part of a defendant. It is from all said that I find that the defendant breached the terms and contract of claimant's employment. Accordingly, I hold that the termination of the claimant's employment by the defendant is wrongful. I so find and hold. Moreover, the defendant's grounds of reason for termination of the claimant's employment as pleaded in paragraph 3 in their statement of defense was that the claimant termination was on the ground of misconduct and underperformance as contained in the schedule of duties, which was provided in the claimant's letter of employment admitted as Exhibit U. It is not in contention that the claimant accepted the terms in the contract of employment. The law is notorious that he who asserts must prove the onus of substantiating the non-attainment of claimant's work performance rests on the defendant. It is now fashionable in labor jurisprudence that an employment should not be terminated without any valid reason. The law further makes a demand on an employer who determines its relationship with an employee to justify any reason it gives in terminating the contract. See the case of the Institute of Health of ABU Hospital Management Board versus Kanyip citation captured. The defendant aside stating that the claimant underperformed at the time he was at work failed to provide credible and cogent evidence to justify or substantiate that reason. That has watered down the assertion of the defendant of the claimant's alleged underperformance. There is no document evincing his performance rating or any other documents in that regard. It is in the light of the apparent lack of documentary evidence on record to substantiate the defendant's assertion that the claimant's employment was terminated on the basis of underperformance that I find that the defendant has failed to justify the said reason for which the claimant's employment was terminated. Therefore, the claimant's termination is said to be wrongful. Claimant relief 1 succeeds. The claimant by his relief 2 is seeking for an order directing the defendant to pay him the sum of 240,000 naira, being his salary for 2 months in lieu of notice. According to the claimant, the defendant failed to give him 2 months notice or salary in lieu of notice before terminating his employment. The defendant, on the other hand, asserted that it issued the claimant a check of 28,000 naira to serve as a salary in lieu of notice, which the claimant refused. It is pertinent for the court at this stage to consider the provisions of the contract entered into between the parties with regards to issuance of notice. Paragraph 8 of the contract states thus, and I quote, that this contract shall be 2 years renewable, meaning in an event where you want to resign or leave the company before the expiration of 2 years, you shall give the company a 3 months prior notice so as to make adequate plans for your replacement. Failure to do so means forfeiture of your previous and net salary or allowance or commissions for 1 month according to labor law, unquote. It is evident on the above clause of the parties' contract, which requires no aid to interpret, that the contract is for a fixed term of 2 years. The law, by the case law authority of Shina Security Company Limited and Afropac Nigeria Limited and other citation capture, is that fixed term of contract of employment is where the contract is predetermined at the commencement of the contract. According to the Apex Court, notice may or may not be in the contemplation of the parties. The preposition here is that the employee cannot be removed before the expiration of a 2-year term, except where he misconducts himself or where the employer dies. Where the contract of employee is determined before the expiration of a fixed term, the employer will be made to pay the full salary of the employee for the unexpired period of the fixed term of the contract. See the case of Shina Security Company Limited and Afropac Nigeria Limited Supra. The contract between the parties in this case is predetermined for 2 years fixed term. The only notice period provided for in the contract is where the claimant wants to resign before the 2 years term. He will be required to give the defendant 3-month notice. There is, however, no notice period for the employer to determine the claimant's employment. The reason for this is simple. It is in view of the obvious nature of the contract, which is fixed for 2 years and subject to renewal. The import of this, as reasoned earlier, is that the parties do not intend for the employer to sack or determine the contract of employee before the expiration of a fixed term of 2 years. And where it does, the consequence is that he will have to pay the employee's salary for the unexpired period of the 2 years, except where the employee misconducts himself. The termination letter clearly states the reason for termination of claimant's employment, and that is for underperformance, which the court has found not to have been justified. It is equally obvious by the letter of termination of claimant's employment that his employment was terminated without notice. It is thus plain here that the defendant determined claimant's employment before the expiration of his term of contract without any justifiable reason. The implication of this going by the term of the contract is that the defendant, and the position of the Supreme Court regarding this type of contract is that the defendant will have to pay the claimant's salary for the unexpired period of 2 years. The contract commenced in July 2019, and same was determined in March 2020. This means that the contract of 2 years fixed term was determined within 9 months of its commencement, leaving an outstanding period of 15 months for its expiration. Ordinarily, the defendant will have to pay the claimant 15 months salary for the unexpired period of 15 months before the expiration of a fixed term of the contract. However, in view of the relief sought by the claimant, which is only for payment of the sum of 240,000 naira, being his 2 months salary in lieu of notice, the law as settled in litany of cases is that courts cannot grant an amount more than what is claimed by a party, but the court may exercise its discretion in granting an amount less than what is being sought for, where the circumstance of the case so demands, but not more than the amount claimed. See the case of Lawal and another versus Umoru, citation captured. The case of Ngwagu versus Idigbe, citation captured. The case of Nitel and Idigbe, citation also captured. It is consequent upon all said, coupled with the case law authorities cited supra, that I find that I cannot award to the claimant's salary for 15 months the unexpired period of his term, his first term of 2 years, but can only grant his claim for 2 years, for 2 months in the sum of 240,000 naira as his 2-month salary in lieu of notice. Accordingly, claimant relief 2 also succeeds. The claimant relief 3 is seeking for the sum of 5 million naira for general damages for unlawful termination and untold hardship. General damages are ordinarily granted by the court as probable consequence of the action of the defendant. I've held that the defendant's failure to issue the claimant 2 warning letters and notice before termination resulted as a breach of the terms of the agreement binding between them, and his failure to prove the reasons for his termination of claimant's appointment amount to a wrongful termination. The law is tried that where breach of contract has been established, nominal general damages will follow without need to specifically plead or prove damages. See the case of Benin and also another citation captured. It is well settled that once it has been found by a court that a party is liable for breach of contract, as in the instant case, award of general damages will follow. And such damages need not be specifically pleaded, as they are not in the nature of special damages. It is only expedient that the actions of the defendant must have caused him some hardship, which in my humble view warrant him to be paid damages. The only remedy for claimant's wrongful termination in this suit is in the measure of damages, which is the salary in lieu of notice. In this case, I've reasoned supra that claimant in relief 2 is entitled to 2-month salary in lieu of notice in the sum of 240,000 naira. To award an additional cost as general damages will amount to double compensation. It is in the light of this that I refuse to grant relief 3. Claimant relief 3 thus fails. It is apparent from all the reasoning above, the claimant's case succeed, in the most part, except his relief 3, which is the general damages. It is therefore, for the avoidance of doubt, that I make the following declarations and orders. 1, that the claimant's contract is for a fixed term of 2 years. 2, that the termination of the claimant's contract of employment was wrongful. 3, that the claimant is entitled to be paid the sum of 240,000 as salary in lieu of notice. And 4, that the defendant is to pay the claimant the judgment sum within 14 days of this judgment, failing which it is to attract 21% interest. I award the cost of 50,000 naira to the claimant. Judgment is entered accordingly. Parties are entitled to clean copies of the judgment. This will be available to you by tomorrow. Very well. So we have come to the end of the sitting. I will rise.